Sir, are you Daryl Sneed?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Sneed, in cause number 25 DCCR 1800, you're charged with a second-degree felony offense of burglary of a habitation from April 29th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? Speak up, please.
Yes, ma'am.
Thank you. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes? And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Sneed is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report, and it'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what's...
His criminal history is very limited, Your Honor. I have no objection to a bond pending sentencing.
Okay. And so, Mr. Sneed, what I'm going to do based on the nature of your plea is reduce your bond to $1,000. I'm going to make a condition of that bond is that if you cannot have any contact or be around or go to the habitation of Billy Davis. What is that address?
595 Ashley.
2595 Ashley. So you cannot go anywhere near that location. Okay. That's part of your bond if you make it. If you make your bond, then it's one of the first things you do is go to probation so they can start that report. If you don't do that, then you run the risk of me not accepting the plea agreement and things could be worse. If you're arrested for anything between the time you make bond and come back for sentencing, obviously I don't have to accept the agreement and things could be worse. And then finally, if you violate that condition of your bond and have any contact with or are around the address that I just stated, then you obviously run the risk of me not accepting the agreement. Do you understand? All right, we'll see. Yes,
I'm
ma'am.
sorry. Mr. Sneed wanted me to ask if the court would consider a personal recognizance moment.
At this point, because of the nature of the offense, I want to make sure that there is some bondsman. It's as low as I can make it at 1,000, so that if he makes that bond, at least there's someone making sure those conditions are being followed.
Yes.
Based on the nature of the offense. Okay. All right, you can go back with the bailiff.
Thank you, Your Honor.
Thank you.
Good morning. Are you Matthew Smith?
Yes, ma'am.
And Mr. Smith, I need you to speak up, please, so I can hear you, and so the court reporter can hear you. Okay.
Yes, ma'am.
Thank you, Mr. Parker. Will your client waive the reading of the indictment?
It will, Your Honor.
Mr. Smith, in cause number 26 DCCR 0073, you're charged with the state jail felony offense of theft of material, copper, and that's from December 8th of 2025. And how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, Your Honor.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached is for a 5-year deferred probation. Is there a fine?
There's not a fine, but it's supposed to be restitution, which I don't know. We didn't have.
So there will be restitution that will be determined for sentencing?
The owner has never turned in a restitution, Your Honor.
Okay,
This is copper from a business.
right.
might have been insurance coverage, but there's never been a form turned in by the owner.
So would you want to waive PSI and go forward, or do you want me to set it for a PSI with restitution to be determined so that if there is some, they can get that to y'all before sentencing?
Well, PSI would be good. Thank
So
you, Judge.
if there's any restitution, then you would be ordered to pay whatever that amount is. Do you understand? As part of your probation?
Yes, Your Honor.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number one.
Objection?
It's admitted. Is there any evidence that Mr. Smith is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do that pre-sentence report and see if there's any restitution that they can determine.
This is the moment where the courtroom strategy really starts to show. Bond decisions after a guilty plea aren't just routine steps. The judge is carefully weighing public safety against giving the defendant one final structured opportunity. A personal bond might sound simple, but in reality, it's a serious test. If the defendant fails to follow the conditions, the entire plea deal can fall apart in an instant.
Ms. French, what is the state's position with regard to me reducing the bond based on the nature of that plea agreement for sentencing?
It's 30 days, Your Honor. Whatever time he gets, he'll get credit for.
Well, if it's a
Probation is a
if
probation.
it's a deferred probation, typically just, so you haven't been in here.
I'm so sorry. I was thinking of another 12-month term.
Yeah, it's
Moving on to the next one. Sorry. I'll defer to the court.
no issues that you see me doing that. So, Mr. Smith, what I'm going to do based on the nature of your plea agreement is reduce your bond to $1,000, but I'm going to make that a personal bond. And so what that means is you're not going to have to pay the $1,000 to get out of jail. You're just going to get out of jail today. But there's some very important things about that. The first is that the first thing you do when you get out of jail is go to the probation department so they can start that process to do that report. If you don't do that, then you run the risk of me not accepting the plea agreement and things could be worse. Do you understand?
Yes, Your Honor.
Also, if you're arrested for anything between now and when you come back for sentencing, you obviously run the risk of me not accepting the plea agreement and things would be worse. Do you understand that as well?
Yes, Your Honor.
All right, then we'll see you back at sentencing. Probation is going to give you some paperwork in just a minute so that you know exactly where to go when you're released today, okay? All right, you go back with the bailiff.
That statement from the court serves as a final warning, short, but extremely powerful. This situation isn't only about being released on bond. It's about whether the defendant truly follows every condition set by the court. Just one missed appointment, one violation, or one new arrest can cause the entire plea agreement to be taken off the table. That's how fast a second chance can turn into full sentencing reality.